Hi, friends. Hello, hello. We're going to have our live with me, attorney Alina Sheltsova. Today, we will be discussing the most interesting developments in the United States immigration. I'm going to be updating you with regard to new asylum policies by the Biden administration that were announced yesterday, September 30th, 2024. We're also going to talk about the settlement with regard to the asylum EAD clock. Very important for those of you who filed for asylum, or those of you who are planning on filing for asylum in the United States. And also, I'm going to give you some updates with regard to USCIS fees, with regard to work permits, one of the most frequently filed applications. So please join me. Let me know where you're watching from, as always. Type up your questions in the chat, because after I'm done with my presentation, I will be answering your guys' questions live. And by the way, if you would like to have a different format of our communications, if you would like to be a guest rather than just somebody who's typing up a question in the chat, email us at office@sheltsova.com. And if you are a good match for the show, I'll be more than happy to consult you live on the show via video, and we're going to have more fun this way. So thank you very much for joining. Don't forget to say hello. Don't forget to like and share this stream. It will be a very interesting stream. There are a lot of interesting updates that do affect a lot of immigrants in the United States. And we're going to break it down by one. I'm going to focus on these interesting developments. So let's start with the easy one, right? Hi, Tauha. Hello, guys. Hi, Penking. Hi, Mohammed. Hi, my guys on TikTok. Don't forget to send me some love, send me some hearts, some stars. So let's start with the easy one. Let's start with the fees. USCIS, again, this is the second time they send a reminder that a lot of people who are filing for USCIS benefits, in this case, work permits, sent incorrect fees. Well, because people are confused. The new fees kicked in April 1st, 2024, but still there is a lot of confusion. Why? Because it's not easy to understand as to what's happening. So the fees changed for work permits. Now, there are no free work permits if you are filing for adjustment of status like it was before. In addition to that, there is a different fee depending on the manner of filing. If you're filing by paper, the default fee for a work permit, if you have to pay a fee, is $520. It is $50 cheaper to submit your work permit application online. It's going to be $470. But interestingly enough, if you submit your work permit application together with your I-45 form, the fee will be $260. So it's a lot of confusion. Now you have to make sure that you do select the right fee. And I personally like to use USCIS fee calculator. You can just Google it, USCIS fee calculator, and it's pretty accurate. Sometimes it is confusing, but in 99% of cases, it's pretty accurate. So USCIS probably is tired of rejecting those applications with incorrect fees. So they sent another reminder. Last week, they were emailing reminders about I-140 form and confusion related to something called asylum program fees for people who are not filing for asylum. Now there is a fee. So, something good to know. It's very important to submit correct fee, because if you don't, what's going to happen is that your forms are going to be kicked back and you're going to lose time. Now we're going to talk about, I would say, negative development in terms of asylum, new restrictions on asylum. Biden administration yesterday did confirm that they are cementing the asylum restrictions at the border. Now, they said that if a daily encounter of people who are coming through the ports of entry exceeds 2,500 per week, the border gets shut down for asylum seekers. You cannot file for asylum at the border, guys. And this measure remains in place until and unless the daily encounters are going to be less than $1,500 per day for 28 days, including, I believe, unaccompanied minors. So in today's reality, it's practically not achievable, this very low threshold of encounters of people who cross the border within the ports of entry, between the ports of entry. So it means that this asylum restriction is going to be in place for a very long time. In other words, the only avenues available for new asylum seekers would be through CBP1 app appointment, and sometimes you have to wait for 300 plus days for that appointment, remaining in Mexico, living in Mexico all the time, or if you come to the United States on a visa and then you seek asylum. So it's very important to know that. At this point, I believe that there will be a challenge to this new rule again. There is already a lawsuit pending filed by human rights organizations, and they will be challenging this new restriction as well. But I'm not sure how successful the challenge actually will be, and most likely it's not going to be resolved by the time of the elections. So this is something you need to know about. There are very narrow exceptions to this rule, that if you come to the United States without authorization, you may still seek asylum. Very narrow exceptions. Usually you have to show that you are in grave danger, that you tried to seek asylum elsewhere, it didn't work, and some very compelling humanitarian reasons. Most immigrants, they will simply not be able to express those reasons. And for that reason, they will be disqualified from any exceptions. So that's something to know about. Now, one last piece of news I wanted to share with you. This one is actually, believe it or not, positive. It relates to asylum EAD clock. Well, EAD is employment authorization document. Many people who file for asylum are anxiously waiting to receive it. But sometimes you don't receive it, even though 150 days passed. You find out after you submit your form I-765 that your clock was stopped. For various reasons, it may happen. Usually, USCIS says that you caused some sort of delay in adjudication of your application. You moved, you changed venue before 180 days passed. Or, for example, you came to your master hearing in court and you stated that you need to find a lawyer so that the court was postponed. And that's how some people lose their ability to receive work permit in connection with their asylum claim. So there was a lawsuit about that. A lawsuit resulted in a settlement. The settlement was signed on September 26. The settlement says that if USCIS decides to stop your clock and not issue a work permit for you, they will have to give you a notice. And you will have an opportunity to challenge such a decision, which is extremely, extremely important. All right, extremely important. Because usually you don't have any opportunity to challenge it, and good luck to you, right? Now, another important thing is that the same settlement covers unaccompanied minors, kids who were classified as such and are waiting for years sometimes to be called for USCIS interview. It also receives another very important class of people who were, let's say, denied asylum, filed an appeal, and their clock was stopped. The settlement says that if your case gets remanded back to either immigration court or to Board of Immigration Appeals, so if it was a federal appeal, you will be credited with the days the appeal was pending for. Very, very important, very, very beneficial for people who get stuck sometimes and lose an opportunity to file that work permit. So it was a great job by, again, non-for-profits who helped to make this settlement the reality. And you need to know that now you will have an opportunity to challenge USCIS determination that your clock was stopped and for the purposes of work permit. And it's a good thing. The settlement will be in effect, or rather, people will be able to do this challenge for at least 6 years after the settlement is signed. So, good thing for immigration world, right? It maybe counters a little bit the new asylum restrictions. And now, if you guys have questions, I'll be very happy to answer them. Please don't forget to type them up. Let me know what is this that you would like to discuss. Hi, Isha. Hi, Kemal. Hi, Danny. So let's start. Hello, Lena. It's been 8 months since USCIS received my response for medical exam and still didn't get any response. Is there anything I can do? Well, I assume that it was all in connection with the Form I-45. If that form is at this point pending beyond processing times, you can absolutely use USCIS Ombudsman, right? Or you can use your senator or congressman to follow up on your application and see, hey, what's up? What's happening, right? Why my case is being stuck. Those measures are usually pretty effective, and I would recommend them first prior to you trying to sue the government. Delay lawsuit is always an option, but I would be careful with that. It wouldn't be my first choice, okay? Let me see if we have some questions from our very active TikTokers who gave me almost 2,000 hearts. Thank you guys very much. It's very nice to see you all. Hi, Terry. Hi, I'm Mahid from Virginia. Yeah, nice to see you too, guys. Absolutely. Thank you very much. Hi, Mohammed. Where am I from? Well, I was born in Belarus many years ago, and now I practice from New York. But I help people in all 50 states and those who would like to hire me if they need US immigration help and they're overseas. Hi, Eunice. Hi from North Carolina. Believe it or not, I used to live in North Carolina. Hi, DC Cowboys. All right. Hi, Jazz. How long after the interview to get a response? Hi, Carol. What kind of interview was that? Was it a USCIS interview or was it an asylum interview with asylum officer? Let me know. How much is required for E2 visa? Hi, Mohammed. Great question. There is no set amount by law. E2 visa is a non-immigrant business visa. But what happens here, you may think it's a good thing that there is no set amount. But what happens here is that USCIS has a great flexibility in determining whether or not you gave them enough money. Well, not them, but for the investment. Usually, if we use old guidelines where they actually stated how much they want to see, your investment has to start with $100,000. Even though if you really dig into various decisions, you may find that investment as small as $67,000, about $70,000 worked for each visa. Currently, it should be at least 100 grand. And for 100 grand, you would have to be the sole owner of those 100 grand, okay? This is what happens. So just keep this in mind. And sky is the limit, of course, but they will see if you have partners, how much partners have. And you need to show that you are a majority investor or almost majority investor. It's very important. The investment must be significant, okay? That's what is happening here. Hi, Richard. Can I talk to you in private? Of course you can. You will need to book an appointment. Please call my office from 10 a.m. to 6 p.m. We're picking up phone calls and you are free to make an appointment. You can also make it on our website, shaltsova.com, and have a private consultation. All right. Hi, Fidel. Could you explain to me how to apply for my family to get in the United States? And what do I need to do? To invite a family member to the United States on the green card, you have to have status. Depending on your status, let's say you are a green card holder, you will be able to sponsor only your spouse, your child under 21, or your child over 21 years old, but they have to be unmarried, not married. If you are a citizen, now you can sponsor your spouse, your children under 21 or above 21, married or unmarried, and even your siblings. But the wait time for each of this category of sponsorship will be different. All right, the longest processing times are for siblings of US citizens. It may be as long as 15, 20 years. The shortest times are for those who we call immediate relatives. Immediate relatives would be spouses of US citizens, parents of US citizens, and children under 21 of US citizens. Everybody else is somewhere in the middle, waiting for at least currently 4 years. So just keep that in mind, okay? Hi, Anvil. Do I have to file I-765 and I-45 by mail to get a decision on I-765 fee? What if I want to file I-765 online? I think there are rules about who can file I-765 online. It's not for everybody, unfortunately. If you filed I-45, well, first of all, to file I-45, you have to have basis for a green card. You can't just submit I-45. You have to have also a basis for the green card. Usually it will be I-360, I-140, I-130 form. So if you can't file I-45 because you already have a basis or together with a basis, then of course you can also file together I-765, right? And then you're going to have this $260 fee. And by the way, I-45 form is pricey. It's almost $1,500, just so you know. But if your eligibility for employment is based on something else, let's say TPS, then your fee will be different and the manner of filing can be different as well, all right? So we need to know the basis and we need to know why you're filing for I-765. That's what determines the fee. By the way, if you filed for your adjustment of status prior to April 1st, 2024, you still don't have to pay for I-765. So that's a good thing. But it's only for those who filed prior to April 1st, 2024. All right. Hi, Mahit. Have you heard of a settlement, TPS? Can you elaborate it, please? Well, there are various settlements, but if you're interested in what's called a carcerate settlement, I believe that's how you pronounce it. There is a settlement related to people who received TPS, temporary protected status, and who afterwards received a travel document based on TPS, and then they traveled out of the United States and returned, and now they have an opportunity, because now they're paroled, they have an opportunity to file for adjustment of status. These people have until, I believe, January of 2025 to file for a motion to reopen their old removal orders, to fix their situation. And the importance of that settlement is that there is what we call a sunset date for the settlement. If you are within the specific time limit filing for that motion to reopen, it should be easier for you to receive prosecutor's consent. And the motion to reopen becomes a joint motion to reopen, which are typically, not always, but typically are granted by the judges. So that's the settlement in relation to TPS that some lawyers probably updated you, and now you're curious about that. And the reason why they updated you is because AILA, American Immigration Lawyers Association, issued a reminder to immigration lawyers to tell their clients that there is this deadline approaching. All my clients are aware of it, but that's of course good to know, and you should know about that too if this situation relates to you at all. Hi, Anne, can you have a prenup and postnuptial prior to marriage for a K-1 visa? Absolutely, of course you can. You can protect your rights the way you want it. It's not prenup agreement or postnuptial agreement. It's not an indication that your marriage is not real. Hi, Winnie. Hi there, I got my green card last week, but incorrect my birthday, the year. Happens all the time. It could have been typo that you made. It could have been typo that USCIS made. If the USCIS made the typo, to correct it, you don't have to pay the fee, but you will have to wait for a long time for them to process the new green card. is going to be usually 8 to 9 months, a very long time. If you made the typo, then you will have to pay to correct it, and you still have to wait for 8 to 9 months at least, right? So if the birth date is a pretty significant mistake. If I would say the gender is incorrect, it's not, I mean, it's obvious mistake, right? But the birth date may create a problem when you're traveling, so I would probably file to correct it, okay? Hi, Janet. Can we apply parents' visit visa on a green card? Well, for your parents to come and visit you, if you just have a green card, you don't really have to file anything for them. They will have to submit for the tourist visa with a US consulate overseas. And some people prefer, but it's not required, to submit a letter of support for them, explaining that they will come for a short time, they will stay with you, and you're going to cover all of the expenses. All right. And again, not required. You can do this letter, but it's not a sponsorship for a green card or petition where your filing actually matters. What's going to matter here is the consular, our officer's opinion about your parents, whether or not the officer believes that your parents will stay in the United States. Okay? It's a 50-50 chance. I would say to the clients, I've seen it go different ways, so I won't be able to really tell you what's going to happen, but they can try. Hi, Raza Khan. Will we be eligible if we win DV lottery with pending asylum but entered legally? Usually not. You will not be able to. You will not be able to adjust if you win DV lottery in the United States if all you have is asylum pending status. Some people are maintaining their lawful non-immigrant status together with their asylum. If that's the case, then yes, you will be able to adjust. All right? Hi, Tiger. What does no case found means in asylum? Nothing. If you decided to track your asylum case on USCIS website and receive the message no case found, it means only that the case is confidential and you're not going to get any updates. But if you have that receipt showing that the case was assigned a number, don't worry about that. Then you're fine, okay? Hi, Starlight, citizen parent for unmarried children. All right, so if you are a parent for unmarried children and you're a citizen, you can submit I-130s for them. Depending on the children's age, it may take only a year and a half if the children are overseas to 15 years. All right, very depends on what's happening there. Because if the children age out in the process or they're above 21, they're going to stuck in the process sometimes for a long time. Even though let me take this back a little bit. If the kids are under 21 and you're a citizen and you file for them, even the case is pending for a long time, the kid's age is going to be frozen at the time you filed for them, unless they get married, okay? But if the children are married but over 21, it may take a very long time. And if they marry, the category shifts. So it's a lot to take into consideration. And unfortunately, in terms of family immigration, the United States is one of the worst places to be in. It's extremely slow, all right? Hi, Memories, you, LGBT, particular group here. Can I petition my partner? LGBT permanent resident. Can I petition my partner? Yes, you can. But what happens is that usually if the partner is in the United States, you will be able to only start the process for them by filing I-130, depending on the partner's status. If the partner is in legal status and has been in legal status since the entry, then after a while, they will be able to file for adjustment of status and wait for the green card. If the partner is not in legal status, you start I-130, and then you either have to qualify for parole in place, which is frozen right now, but the possibility, or I-601A waiver for the partner to benefit from this application. However, if you become a US citizen and the partner has a legal entry, then they don't need to deal with a waiver. They just have to wait for you to become a US citizen, and they will be able to get a green card in the United States, even if they overstate their status, provided initially they entered the United States legally. If the partner is overseas, they will just have to go through consular processing, all right? That's how it works. Hi, Najo. What is the processing time for I-45 after asylum approval after a year? Usually it gets granted within a year, but some cases are pending for more than 3 years. All right. Hi, God's Angel. I was forced to pay for a green card. Everybody's forced to pay a green card fees, okay? But not sure what happened here. Thank you, Memories. Thank you for the rose. Hi, Redo. My fiancé visa is denied and the marriage is over before I get a green card. They put me in removal proceedings. That is not right. Fiancé visa can be received only if you're overseas. Not sure what's happening here, because removal proceedings can be started only if you're in the United States. So perhaps I-130 was denied and the marriage was over before you completed the process, and that's why somehow you are now in removal proceedings. Then let's see if you can have any defenses against the removal proceedings. Would you qualify for VAWA, or VAWA cancellation or removal? Or maybe you're married again and you can file for a new adjustment of status. Maybe you can file for asylum as a defense for removal. Maybe you won't be able to get asylum, but maybe you will be able to get withholding or removal. So I think this is an excellent example of when you should consult with an immigration attorney in private, because once you're in removal proceedings, you have to have a strategy how you're going to be getting yourself out of the removal proceedings. Sometimes you would just seek prosecutorial discretion and dismiss the case. Most of the times in this situation, you're not going to have any status or even a work permit. Sometimes you can file for something in removal proceedings, which is available only in removal proceedings, and it can be a good thing for you. But I just do not know what's happening there, you know? All right. Hi, Joseph. I need my French citizenship, but my girlfriend won't marry me. Ouch. I wish I could give you French citizenship, but we're discussing only United States immigration here. All right. Hi, Sally Dunor. I use different passport to travel while running from persecution. All right. So if you entered the United States on someone else's passport, as long as it was not a US citizen's passport, you may still have a chance to get a green card in the United States, but most likely you will need a waiver, okay? Just need to know that. Hi, Govinda. Hi, Lena. What is the good solution for pending asylum process? It's been pending since 1.5 years ago. Govinda, you'll have to wait. The problem is this, that recent lawsuit practice show that if your asylum is pending for less than 4 years, the judges are not even going to force USCIS to give you that interview because processing times became ridiculously long. So if it's been only 1.5 years, you just will have to wait, unless you have a very strong good reason to try to expedite the case, okay? Hi, Luis. How difficult is it to bring someone from Ukraine for asylum status in the United States or as a refugee? Or is it easier if I marry my Ukrainian fiancé first before having her to come here with me? All right, so your fiancé, if you guys have a relationship, doesn't need any asylum. It's not probably what they need. Asylum, first of all, is for somebody who is already in the United States. And it's for somebody who is unable or unwilling to return to their home country due to fear of persecution based on race, nationality, political views, religion, or membership in a particular social group. A person who is running from the war unfortunately, usually will not qualify for asylum without more. But if you have a relationship with somebody from Ukraine, you need to know that currently the law allows you to file for that I-130 for them if you guys do get married in Europe, for example, in person, and make the process very fast in person. I think Frankfurt, Germany is processing such applications. Okay, so you don't have to wait for a year. There is another option for you to help a person and bring them from Ukraine on U4U program. All right, parole program. So, sorry guys, you do have options here. Okay, you do have options. Asylum is just not the right route. Okay. You're welcome, guys. Welcome, welcome. Hi, Hiwi. Can someone file DV lottery while in the United States and have VAWA case pending? Yeah, DV lottery starts tomorrow, right? So everybody's asking about that. Anybody can file for the DV lottery, whether they're in or out of the United States, as long as their country qualifies for it. And don't forget to tell the truth about yourself. The better question would be, if you win that DV lottery, will you be able to benefit from it? In most situations, if a person is already in the United States and they do not have legal status, or they just have something pending, they will have to leave the United States and try to benefit from the DV lottery overseas. But prior for them leaving, they have to make sure they're not inadmissible. They did not accumulate unlawful presence time, usually, that will become a problem for them coming back and would require a waiver, which they will not be able to receive. Okay. But if you have TPS, you will be able to adjust here, provided, of course, your numbers for adjustment are also going to be within the fiscal year, current within the fiscal year the government is processing those DV lotteries. So my take on that DV lottery, guys, participate, tell the truth in your initial filing. It's very important. Participate, and if you win, we're going to deal with it later, all right? Because it's free. It doesn't cost you anything. Unless, of course, if you use some third party, which I don't recommend you doing. They make tons of mistakes usually, and sometimes you lose your chance just because they made those mistakes. Hi, Christopher. Nice to see you here. Hi, Ryan. Best way to apply green card after F1? Through employment. That's easy. You either have to find an employer who is willing to sponsor you and maintain your status. Usually, a typical F1 would first jump to H1B and then to employment, green card. Or you have to have enough qualifications to file for yourself using EB2 national interest waiver. How long does NVC takes to approve DS260? You mean to review and to let you know that the case is documentary qualified? Up to 90 days. That's the default time. All right. Hi, Diata. Can I file for my fiancé K1 while she is studying with student visa in Canada? Yeah, you should be able to, right? Yep, you can. Yep. Can I reapply second I-130 if I get I-824 hold? I remember we had a similar question last time I was live. Yes, you can. Yes, you can. All right. Let me see. Hi, Shelley. If you file for asylum and you leave the country, can you enter back? Usually not. Even though I do know some individuals who are successful. Well, what happens if you have asylum pending and you haven't had your interview? To leave the country to travel, you should request advance parole. And it's not really for leaving. The United States doesn't have what's called an exit border. It's for you to be able to come back. But usually such a question pops up when you leave the country and you don't have advance parole to come back. I know cases where people came to the point of entry and they explain that they have asylum pending, they had emergency, and they get paroled back. But it's not a guarantee, all right? And I would never recommend my clients to try this. You should really do it the right way. You should file for advance parole and then come back without headaches, all right? It's very important, very important. Hi, Shell D. If my fiancé is undocumented, should I fill out I-130 or just get married? You cannot fill out I-130 if you're not married. I-130 is only for married couples. I-129F for fiancés, but that's for the visa, for those who are overseas. So in your situation, most likely, again, guys, I'm giving you this very short direction based on the facts that are in front of me. In your situation, most likely, you will have to get married first and then try to fix the situation. Success depends on several factors. If your undocumented fiancé entered the United States with an inspection or parole, did they have any criminal or immigration history? Can they be argued that they're inadmissible? Some people who claim to be a US citizen for a variety of reasons in the United States may be found inadmissible. So don't even start the process. Don't wait this $3,000 in filing fees, okay? So that's all. This is very relevant when you make your decisions to invest your time and money into the sponsorship process. And that's why you pay usually for consultation, to discuss the chances, discuss the process for your particular case, because there are some little things that may pop up and make a huge difference, okay? Very, very important to know that. Now, guys, thank you very, very much for joining. It's been about 36 minutes, 37 minutes. I've been with you, and it was a pleasure. I got almost 5,000 hearts on TikTok. Thank you very, very much. Today was a great day for TikTok followers. I hope you find this information helpful. Do not forget about DV lottery opening up, right? Participate. Make sure you tell the truth. Make sure you do not exaggerate your qualifications. It's very important. If you're married, say you're married. If you're not married, say you're not married. Don't forget to mention your children, guys. Extremely important. Some people forget to mention children. Whoever gives them this great advice not to do that. Later, when they go for visas, they find out the whole family cannot come in because they forgot to mention a child who doesn't even live with them for various reasons. So make sure that you don't make such a silly, silly mistake, okay? And of course, always upload your up-to-date recent photo. Why I don't like those middlemen who help you to file for DV lottery? You give them your photo from 10 years ago and they keep resubmitting it. If you get selected and USCIS sees that the photo is from ancient times, they will disqualify you. You're going to lose your chance in the most silliest way possible. All right. Thank you guys so much for the hearts. All right. Since you so actively gave me so many hearts that I have almost 6,500 of them, let me answer last question. Hi, Sony Miami. I applied for my brother and sister in F4 category in November 2009, and they are from Pakistan. How long is the process? All right. To answer this question, we need to go to something called Visa Bulletin. I'm going to open it right now because I don't remember it. I remember many different things, but not the chart, 2 charts for every category from Visa Bulletin. And it's going to tell us exactly which applications are being considered in F4 categories with filing days. So final election dates in F4 category currently for October 2024. Priority date has to be August 1st, 2007. You filed in November 2009. If everything is going to be developing squarely or proportionately, your family members will have to wait for about 2.5 years until the visa will be available for them, okay? But it not always works like that. It's not always that the Visa Bulletin moves with our calendar. It may shorten, it may expand, be slower than our calendar. So what I recommend people is every month to check, especially when you come to this close timing. Every month you basically check if for them the date is approaching. Do not miss the priority date. It may be extremely important for their children in F4 category who may be aging out for calculation of the true age of the child in connection with the Child Status Protection Act. I know it's a lot of information. You will be able to watch it in recordings on YouTube and Facebook, guys, all right? Because it's tons of information. If you're not an immigration lawyer, I'm trying to break it down as much as I can, but it's all very, very important, okay? Hi, Pasma, does it make sense for DACA got after 21 to apply for DV 2026? You accumulated some unlawful presence time probably, and you may be inadmissible for 3 years. Now you have a DACA, and you most likely have to travel overseas. Unless you would qualify for a waiver, which must be approved in a very short time. In a typical scenario, it's not going to make sense. But I do not know all of the aspects of your situation. What if you don't have unlawful presence, all right? And it's not a problem for you. What if something changes also? So what if you already traveled and came back on parole and your unlawful presence time was running in the United States, that bar? I don't know all that. So why don't you consult with an attorney? But listen, apply for DV 2026. It doesn't hurt, all right? It just doesn't hurt. Wow, for this 10 minutes that I was speaking with you guys, I already have 10,000 likes. It's really, really amazing. Really amazing. Hi, Huey. My lawyer is waiting for a fee to submit the therapist evaluation for VAWA. It has been 3 years. Can that affect it? Yes, it can. But for VAWA cases, any lawyer should know if they took the VAWA case, guys, you do not have to wait for the error fee. VAWA is one of those very rare categories of cases which you can update whenever you feel like it. There is a hotline for VAWA, and this is one of the tools that sometimes that we use. This is like a priceless tips for all stock VAWA cases. You send them your updated documents, asking them to update the file and to make a decision on the case. Please tell it to the lawyer or come to us so we can take care of you, okay? 917-885-2261, shaltsova.com. That's how you find me if you need my help. Thank you very much, guys, and I hope to see you soon. Don't forget to sign up for my social media, Facebook, YouTube, TikTok, and I hope that we're going to meet each other back this coming Friday. Thank you, and I hope to see you soon.